Madison is a Paul. He basically in his entire adult life doesn't really have an honest job, except actually as a public servant. That's unlike many of the other founding fathers who have their vocations or professions as lawyers, as printers, as financiers, as planters. He feels viscerally that there is an unfairness that's being visited upon his neighbors who happen to be of a slightly unorthodox religious persuasion. Madison viscerally has a certain sympathy for religious outsiders because he himself is an outsider of sorts. We now think that he suffered from epilepsy or something in the epilepsy family. At the time, there was a lot of a bigotry, superstition against epileptics. Many religious people thought that epilepsy was the mark of the devil or something like that. So, and Madison keeps this a secret, his medical condition. He enters political life at a very young age. He's still in his early 20s, and it's at the beginning also of independent America. So his life and America's life actually are in sync. And Virginia is declaring its independence and creating a constitution, and this pipsqueak that no one's ever heard of before, he's still in his 20s, manages to get into the center of the action and not only participate in conversations about religious liberty, but actually contribute some really important language. George Mason, very much Madison Sr., very famously has come up with a draft Declaration of Rights. And Madison actually has the temerity and the self-confidence to propose basically two fundamental amendments. He says we shouldn't call this mere toleration, kind of acceptance of religion as a matter of mercy, grace, favor. We should actually call it free exercise, not merely toleration, and it shouldn't be an ought. It should be basically a shall of a certain sort. It should be a right, and not merely something, again, as a matter of grace. And his amendment carries. So, and that's 1776. That's actually before the Declaration of Independence, really, the month before. It's now almost a decade later, and he is partnering with a very notable Virginian, his senior, Thomas Jefferson, whom he's met back in 1776. And what brings the two men together intellectually is their commitment to religious freedom. And Jefferson is off in Paris in the mid 1780s, and so he leaves it to his lieutenant, his deputy, his ally, his friend, James Madison, to push for the reform against the establishmentarians, the established church folk in Virginia, led by a very powerful politician, former governor, named Patrick Henry, and together Jefferson and Madison, with Madison being the guy on the ground, get this very important bill passed, a Bill of Religious Freedom, 1785. Most of the other states have established churches, and in none of the states is there an emphatic, ringing declaration of this sort, a prohibition on religious discrimination of the sort that we see in 1785. In every state except Virginia, there is a requirement in the Constitution, basically, or in statutory law, that one have a certain set of religious beliefs and commitments in order to be a public servant, in order to hold governmental office. So Virginia is the only state where there's actually an emphatic prohibition on that sort of thing, thanks to Jefferson and Madison. you might ask then, okay, if all that's so, if James Madison viscerally understands religious freedom, it's instinctive for him, even before he begins his political life. And his political trademark is very much associated with religious freedom. In 1776, working with George Mason in 1785, allying with Thomas Jefferson. If all that's true, why, when Madison ends up at Philadelphia, doesn't he push for a nationalization of this right? Why doesn't he push for a Bill of Rights? And in fact, the cast of characters in Philadelphia involves none other than George Mason, who says toward the end of the Philadelphia Convention, listen, we should have a Bill of Rights. And you can see that he's basically thinking, I, George Mason, helped draft the Virginia Bill of Rights when Virginia had a constitution in 1776. Let me do it again for the federal constitution. And Madison basically opposes Mason in Philadelphia, as do most of the other delegates. And this turns out to be a massive mistake, because the absence of a Bill of Rights is one of the two biggest criticisms of the document when it's proposed to the people for ratification. And it's obvious why the people would notice that, because they are aware that there are state constitutions on the books. That's what 1776 is all about, independent state constitutions. And most of these state constitutions have bills of rights. And so the absence of a federal Bill of Rights is obvious to every farmer, every shopkeeper on day one. They look at it and they say, dudes, you forgot the rights. And that was not utterly unexpected. So why did Madison oppose Mason? Why did the Philadelphia delegates omit a Bill of Rights? And I think, truthfully, the answer is just a really simple one. They were tired. They wanted to go home. They thought this would take actually a couple more weeks. George Mason says, I'll be able to bang something out very quickly. And you can see the wheels in the minds of the other delegates starting to spin. They say, yeah, this is going to be another 2 weeks, and we want to go home. Then the next question is, how does Madison pivot from that? Madison is a Paul, and he understands at a certain point that this was a mistake to omit a Bill of Rights. It's a mistake in at least two ways. One, it ends up making ratification of the Constitution more difficult. And he's invested a lot of himself in that Constitution. And the two biggest objections to the proposed Constitution is Congress is too small to be genuinely representative. There are going to be 65 people in the House of Representatives for all of America, compared to 1,500 people in the lower houses of their 13 respective state legislatures. So 65 versus 1,500. Okay, you see the difference. Virginia's going to have 10 representatives in Congress compared to 400 or so in Virginia itself at the state level. So people say the legislature is too small to be genuinely representative, and you forgot the rights. So in order to get the Constitution ratified, Madison needs to begin to be open to the idea that, there should be some amendments. And so you see him pivoting in the Richmond ratifying convention, suggesting a sort of openness to that. And Virginia does ratify. Virginia turns out to be the 10th state, and then New York actually is the 11th state. That's enough for the Constitution to go into effect. You only needed 9 and you got 11. So fine, the Constitution's going to go into effect, but now we're going to have to elect those members of Congress. And James Madison wants to be in Congress. He ideally would have liked to be a senator, but Patrick Henry has basically made sure that that's not going to happen. And Patrick Henry is not very pleased with Madison, in part because they had different views about religious liberty back in the mid-1780s. So the Senate is closed to him because Patrick Henry has a lot of power in Richmond, in the state government, and he freezes Madison out. So Madison sets his eyes on a congressional district. But the district has been drawn by Patrick Henry and his allies to be rather unfavorable to Madison. And if he wants to get elected to the House of Representatives, he's going to need to make a pivot. Now, politicians hate to admit that they've made mistakes, and they especially hate to admit that they've made mistakes when they've made mistakes. And the bigger the mistake that they've made, sometimes the more they hate to admit it, But Madison carefully pivots and writes a couple of letters that he knows are going to be published in newspapers, and kind of lets it be known in other ways that he, if elected, will champion a Bill of Rights that in particular includes religious freedom. And he has credibility to do that, unlike maybe other politicians, because actually the Baptists in his neighborhood, in his district, know that he's authentic on this, that he's never been opposed to religious freedom. On the contrary, he's been a champion of religious freedom, even when it hurt him. So they know he's authentic about that, and he ends up getting elected. And he's true to his word. And because he's given his word, he pushes very hard for a Bill of Rights in the first Congress. Because remember, he's got to go and face the people again in 2 years. And he made, in effect, a promise. The conventional narrative gives James Madison a lot of credit for the Constitution and the Bill of Rights. He's conventionally known as the father of the Constitution, the father of the Bill of Rights. I suggest that paternity is a bit overstated. There's at least one other person who has as strong a claim, I would say a stronger claim, to the fatherhood of the Constitution and the Bill of Rights, and that's George Washington. And George Washington is the presiding officer of the Philadelphia Convention. His name, alongside the Constitution, helps guarantee its ratification. He's the unanimously elected president, the unanimously re-elected president. So his connection to the Constitution, I think, is obvious once one thinks about it. But his connection to the Bill of Rights is also very important, because in his inaugural address, and Madison helped play a role in drafting it, in his inaugural address, he publicly says we should think about a Bill of Rights. And we should think about a Bill of Rights in part because there were so many Americans who were very skeptical about the Constitution, and we want to bring them on board. I, as president, want to be a uniter. And people supported me as president who actually opposed the Constitution. The Constitution passes, by a very close margin in a whole bunch of places, and yet George Washington, to repeat, is unanimously elected. And so he's trying to represent the people who voted against the Constitution as well as the people who voted for it. It's skeptics. He wants to bring them on board. He wants to bring North Carolina back into the Union and Rhode Island. And the way to do that is to reach out to them and say, you had a good idea with the Bill of Rights. This was your idea, and we're going to work with you on it. So before James Madison says stuff in the first Congress, George Washington has paved the way, with Madison's help as a speechwriter, but George Washington has paved the way for that in his inaugural address. Fully 10% of the inaugural address is devoted to what we will call a Bill of Rights, and it's really the only news in the inaugural address. Other things are ceremonial and significant, but not really big news. The First Amendment says that Congress shall make no law respecting an establishment of religion. And we say, fine, Smith is not asking for a nationally established church. But note that language, respecting, can be understood as in regards to, on the topic of. Congress shall make no law creating a national establishment, to be sure, but also Congress can make no law prohibiting state-established churches. And at the founding, several states did have established churches. Congress, more broadly, some might say, shall make no law on the topic of religion one way or another. What we call the First Amendment, which was actually initially third on the list of amendments that issued from the first Congress, Madison proposes a whole bunch of amendments. They pass the House, they pass the Senate. In the end, there are 12 that pass both and that are submitted for ratification, but only the last 10 get ratified. So the one that was third initially on the list becomes our First Amendment. What we call the First Amendment actually has rather a lot in common as initially drafted with the 10th Amendment. It's about, in part, states' rights. States can have all sorts of religious policies, and Congress should butt out. Congress should make no law on this topic. So the First Amendment originally is a federalism provision of sorts in at least two respects. First, it doesn't apply against state and local governments. So there's no First Amendment right to have free speech or free press or free exercise rights or jury trial rights for that matter, or search and seizure rights against state and local governments. The Bill of Rights from start to finish is a set of rights against the federal government and only the federal government. And the Supreme Court makes that clear in a landmark ruling by John Marshall called Barron v. Baltimore in 1833. So there's that. The Bill of Rights applies only against the federal government. But second, certain aspects of the bill, what we call the Bill of Rights, are states' rights provisions of a certain sort. Like the 10th Amendment and like this language of the First Amendment, Congress shall make no law interfering with religious policy in the several states, or at least that's one very plausible antebellum reading of the First Amendment. Final point. Here's an analogy. America is a vast land with all sorts of different religions, denominations, and sects. So there are Anglicans, Episcopalians, there are Quakers, there are Baptists, there are Congregationalists, there are Shakers, now there are Mormons, of course, and that only begins that only begins to describe the religious diversity on this continent. Now, the initial solution to this religious diversity is a federalism solution. There won't be a continent-wide policy on religion. We're going to leave this up to local option. So Congregationalists hold sway in New England, and Maryland is a bit of a Catholic enclave, and the Quakers cluster in parts of Pennsylvania, and Anglicans are down south. I mentioned the Baptists, who are in all sorts of places. I should have mentioned the Methodists as well. And so when the Mormons come along, and the idea is not here, move elsewhere, that's a very American idea, at least in the early era. It's a federalism solution to religious diversity, and it is building on a European solution centuries earlier. There were decades, really at least 100 years, of religious warfare in the middle of Europe about angels and pinheads, about consubstantiation and transubstantiation, between Protestants and Catholics. And the ultimate solution for decades of murderous religious strife in Central Europe was a simple federalism formula. That was at the heart of the Peace of Augsburg in 1555 and the Peace of Westphalia in 1648. It's a famous Latin phrase that people may remember from their AP history classes in high school. Cuius regio, eius religio. The religion of the prince will be the religion of the principality. Each little duchy or fiefdom can have its own religious policy, and if you don't like that, you need to move to some other religious fiefdom or duchy. And that brings peace to Europe. There's no empire-wide policy. We're going to leave it to local option. And that's the original First Amendment solution, in which different states have very different religious policies. And if you don't like it, move. In American history, many of the most important developments have occurred at the initiative of outsiders. Baptists in Virginia in the 1770s and 1780s, Jehovah's Witnesses in the 1940s, because that's where the shoe pinches, because they're the ones who are at the suffering end of government inequality and unfreedom. In Gobitis, the Jehovah's Witnesses lost, and the case was understood as a pure religious liberty case. They brought the case, in effect, as Jehovah's Witnesses. When they win in the Barnett case, actually they win on free speech grounds and not religious liberty grounds. And the court actually does not give any particular emphasis on the fact that their objections to this compelled salute of the flag is religious in nature. The court, in effect, says no one, religious or not, can be forced to salute a flag, to engage in a kind of act of political obedience of that sort, ideological obedience. And courts in America are open to hear all comers, whether powerful or powerless. And Lady Liberty is, in principle, blindfolded. She doesn't know about the political power of the plaintiff and the defendant. She's just holding the scales and trying to determine which argument, legal argument, has more weight. The big idea is if you're going to mess with rights, there has to be a very, very good reason. Some people think that rights are absolute. They're trumps, and they always prevail where they apply. And then the game becomes defining where they apply and where they run out. Oh, freedom of speech, yes, but not of conduct. Okay. So that's one way that courts operate. They just define the scope of the rights. But sometimes courts instead say rights aren't necessarily absolute. They just carry very, very great weight. And it's going to take something extremely strong on the other side to outweigh the claim of right. And in legal jargon, we call that a compelling state interest, a compelling governmental interest. What exactly does it mean? Is it just a kind of balancing? And if it's a kind of balancing, how much protection does that give to particularly unusual religions, small religions, minority religions? Some folks have said the test shouldn't be just how does the court weigh the government's interest versus the alleged religious claim. It should be something more like the John Stuart Mill principle, no harm to others. So that if the only thing that the government is trying to do is to prevent you from harming yourself, well, maybe they can do that if religious liberty isn't involved. Maybe they can say, you have to wear a motorcycle helmet to protect your own cranium. You have to wear seat belts to protect yourself from injury in an automobile accident. So the government can act paternalistically in certain ways, but it shouldn't where your objection is religious in nature. If your objection is religious in nature, you should prevail as long as you're not harming someone else. So if that were the analysis, then maybe the government could say no one in general can handle poisonous snakes because they're dangerous, they're venomous. But if you're doing so as part of religious service, we'll let you do it. But we're not going to let you sick the snake on some non-believer. Okay? You can practice your religion, but you can't throw other people into the volcano to appease the volcano god. And if that's the analysis, you're going to have some interesting questions about children and whether who are not yet of age, and whether the government has a compelling interest in protecting them from certain harms to themselves. They were overruling Employment Division versus Smith, supported by a broad consortium of religious institutions, interfaith, many mosques and churches and synagogues and their leaders supported this statute designed to overturn Employment Division versus Smith and reinstate an earlier regime saying where religion is involved, it has to be specially accommodated unless there's a compelling state interest, compelling governmental interest. The law actually mentions the Smith case in effect by name and says we want to go back to an earlier case, a case called Sherbert. And so Congress here is telling the court that they got it wrong. Court doesn't like to be told by Congress that they got it wrong. And so the court actually has invalidated half of the Religious Freedom Restoration Act, the half that applied this earlier regime, the Sherbert regime, to state and local governments. So the only part of the Religious Freedom Restoration Act that survives is the part that gives religious worship special rights, special protection against the federal government. But insofar as RFRA tried to restore special protection, special accommodation against states and local governments, RFRA has been set aside by the Supreme Court in a case called City of Burney v. Flores. (1965) is a watershed year. It generates at least 3 landmark statutes that change America profoundly. Many understand the significance of the Voting Rights Act of 1965, which puts teeth into the Reconstruction promise that blacks are going to be able to vote on equal terms with whites. That was revolutionary. And it was a core commitment of Reconstruction, and it wasn't enforced for a very long time, just like incorporation of the Bill of Rights wasn't enforced for a very long time, or racial equality in non-voting domains like education wasn't enforced for a very long time. Now, to enforce voting rights, you're going to need Congress as well as the court involved, and the Voting Rights Act of 1965 transforms America. Without it, there's no possibility of President Barack Obama. 1965 will completely realign political parties. Southern Democrats will actually leave the party and become conservative Republicans. They'll push out of the Republican Party Northeastern liberal Republicans who will become Democrats. So 1965 realigns America profoundly. It's as important as many a constitutional amendment. That's in the voting domain. There's another statute in 1965 that's hugely consequential for our social safety net, for our welfare state, a modification of the Social Security Act that we call Medicare and Medicaid. Hugely important, especially for us senior or about to be senior citizens, and for people who are poor and need government assistance for basic health needs. So 1965 gives us Medicare and Medicaid, and it gives us the Voting Rights Act, and it gives us this third hugely consequential statute, the Immigration Reform Act of 1965. Before the Immigration Reform Act of 1965, it was almost impossible to come to the United States from certain parts of the world, including the part of the world where my parents come from, the Indian subcontinent. When my parents, through a kind of loophole, got to America before 1965. And when I'm born, there are almost no Indian Americans in my neck of the woods. We moved to the Bay Area. And in the early 60s, in the San Francisco Bay Area, there are almost no Indian Americans. I know that's impossible for people to imagine today, given San Francisco and Berkeley and the Silicon Valley. But when we are there in the early 60s, we are one of a handful of South Asian families east of Oakland. And that's because before 1965, in order to come to the United States in general, you could come only if people from your native land were in America in certain numbers in the 1920s. There was a national quota system set up in which immigration numbers from each country were set by the numbers that existed in 1920. And in 1920, there weren't people from India in the United States, so you couldn't get here very easily in the 30s, 40s, 50s, and early 60s. If you're going to have people from all around the world coming to America, not just from Northern Europe, not just from Western Europe, not just from Britain or Britain and Ireland or Britain and Ireland and Germany, but you're going to have people from China and Japan and India and the Philippines and Indonesia. If you're going to have people from Africa and Asia coming to America, they're coming to America with all sorts of different religions, not necessarily in the Judeo-Christian tradition. They are going to be Confucian and Buddhist and Hindu and Sikh and Muslim and many others. And that's going to profoundly change the nature demographically of religion in America. The tradition of religious liberty protects their right not to have a religion, their right to be agnostics or atheists. They can't be forced to profess things that they don't believe, any more than religious people can be forced to profess things against their deepest understandings of the universe. So that's one point. A second point is that people have to be free to change their minds. Just autobiographically, I started out kind of on the atheist agnostic side of the spectrum. I've changed my mind over the years. And I've changed my mind in part because America is a land of profound religious freedom in which my fellow citizens are able to come up to me and say, oh, let's talk about the eternal. Here's what we think. What do you think? And then that's what it means to truly be free, is to actually be able to hear arguments and then decide for yourself. So if you're atheist today, you might not be atheist next year. And if you're religious today, you might not be religious next year. It goes both ways. We have far more religious practice, far more church going, and far less governmental establishment. If you're of a libertarian sort, you might say, this is not a surprise, this is not a paradox. Government messes things up, leave it to the private sector. If you have total private freedom in the marketplace, that's going to generate competition and for high quality goods and services at low prices. If you have religious competition, the religions are going to have to sharpen their understandings and their offerings, try to make themselves every generation relevant to the people that they're competing to persuade and to keep. And so, just to repeat, the rest of the world has a lot more established religion. America actually has a lot more religious practice, a lot more church going. Just compared, say, to the mother country, England. England has an established church, and there's a lot less actual religiosity among the English people compared to the American people. The Anglican Church, it's an established church, and you can't be the head of the state unless you actually agree to be the defender of the faith. And now that's going to affect what your positions can be on divorce and remarriage and all sorts of things. It means the freedom to decide for myself what I think about the deepest questions in life about the infinite, about the cosmos. Thomas Jefferson said that if someone has unusual religious views, he says, well, that does not break my bone or pick my pocket, okay? We all have to have certain rules that we all abide by. We either all drive on the right side of the road or on the left side of the road, and it will not work if we just get to choose. Every day we get up and say, oh, I think I'm going to drive on the left side today. No, that's not going to work, because there are certain things where we actually have to coordinate our behavior. We have to have rules about what's mine and yours and how I can transfer what's mine to you voluntarily. We have to have rules against force and fraud, against murder, rape, and robbery. We inherit a planet together. We have to work with each other as human beings who respect each other. So we have to respect each other's rights and freedoms. We have to coordinate our behavior in certain ways. We need laws for contract, how we can build things together, and again, property, what's mine and yours, and criminal law. But we don't need rules for how I get to think and how you get to think, especially about really important things like the meaning of life. So the first step is religious liberty at the state level, beginning with Virginia in 1785. And the second step is protection of a religion at the federal level with the First Amendment. And then the third step is applying that against the states in the text of the 14th Amendment and the case law, beginning in the 1940s, that's going to protect religious liberty against state intrusion. And then this next step is going to be protecting religious liberty even when there's arguably a neutral law. It applies to everyone, but religions are saying, actually, but we want a special accommodation, a special exemption from a religiously neutral law. For example, there's a general prohibition against the use of wine. And a religion says, okay, that's true. Generally, people can't use wine, but we would like to use wine in our sacrament. And so we'd like an exemption, an accommodation from the general law. So that's the next step of religious liberty, above and beyond merely protecting religious belief, protecting religious action, and even religious action when there's a neutral secular law in place. There are at least two issues. One is, what is the proper scope of religious liberty? And a second is, who decides? So let's just take them in order. You could think that religious liberty is simply a right against laws targeting religion as such. And you could point to the words of the First Amendment: Congress shall make no law abridging the free exercise of religion. Well, if it's going to be absolute, no law, it's going to have to be about laws that are aimed at religion as such. And if it means that, it can be absolute. No law means no law. They just can't pass a law aimed at hurting the Catholic Church or the Mormon Church or what have you. But the moment you actually say, it's not just about laws targeting religion, but about laws that have an adverse effect on a religion, it can't be absolute at all. Because some religion may pop up. It might not have even been on the books when Congress passes the law. Congress passes a law saying, you can't throw people into volcanoes. Fine, that seems like a pretty good law. But some religion comes along and says, we want to throw non-believers into volcanoes. Well, no law can't mean no law in that situation. And if you have an accommodationist vision. Now, on the strict view, this is not a law aimed at religion. It was just a law prohibiting everyone. They didn't even know about the volcano religion when they passed it. So the argument for Smith is that the words shall make no law abridging mean no law designed to abridge, aimed at abridging. It's that the moment the law is passed, was the legislature actually focused on hurting a religious practice as such. Now, let me make the argument on the other side. The 14th Amendment changes all of it. So that argument is a very good argument for Smith. Why Smith is right, why Scalia is right. If no law is absolute, there's no balancing test, that will only work if we define the right narrowly. And the right defined narrowly is just a law against religious persecution, against laws targeting religion as such. If that's what it means, that's absolute, and we can enforce it absolutely. But it doesn't generate a right of exemption, of accommodation. Now let me argue it the other way. The key provision of the Constitution isn't the First Amendment, it's the 14th Amendment. It's about how religious rights now apply against states and localities, and the key language borrows from the First Amendment that modifies it. Same words, shall make no law abridge. Oh, but it's now no state can do it. Oh, but they add a couple of additional words. No state shall make or enforce any law which shall abridge fundamental rights, including religious rights. Well, if it's now we're focusing on the moment of enforcement and not just the moment of making, now we should focus on whether the law as enforced is actually pinching the religion in a certain way. Okay, so, but then you say, but still we have to have some sort of absolutist test. There's no balancing test. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And then the argument would be, it can be enforced absolutely without balancing how important the state's interest is versus the individual religious claimants' rights are. We can have an absolute categorical approach if it's a true privilege. And here's what a privilege is: something that doesn't affect adversely someone else, that doesn't break someone else's bone, that doesn't pick someone else's pocket. We will accommodate religion, but even against a general, neutral, secular law, but only when the people who are affected are members of the religion itself and no one on the outside is hurt. So that's the debate about what the right means. Now, as to the debate about who decides, well, the 14th Amendment is enforced in courts, of course, but it also ends with language, Section 5, saying Congress shall have power to enforce this. And one way of understanding the 14th Amendment is if the court thinks that a state has violated the 14th Amendment, it will jump in. And if Congress thinks that a state has violated these rights, it will jump in. And in general, the states have to meet whatever bar is higher, the court's bar or Congress's bar. That would be one sensible way of interpreting the 14th Amendment. We have both entities of the national government trying to enforce rights generally, religious rights in particular, courts and Congress, and states have to meet whichever standard is more demanding. But that's not what the court thinks. What the court thinks is we, the courts, decide everything, and Congress can't tell us what to do, even when Congress is being more generous to a right. Argument on the other side is, actually, the 14th Amendment was written by Congress, for Congress, and the only institution of government that's actually mentioned by name in the 14th Amendment is Congress. Congress shall have power to enforce this. Now, in the short run, courts protect rights, and sometimes Congress protects rights. Oh, but in the long run, it has to be we, the people of the United States, because in the long run, we pick who Congress is. We pick who presidents are, we pick who senators are, and they pick who justices are. So in the long run, religious liberty will not survive and thrive unless it lives in the hearts and minds of the American people. That's where 1965 becomes so interesting and important, because we, the people today, look very different than we, the people, look when I was born in 1958. And we do, because so many more of us are coming from, or have ancestors from, Asia and Africa and South America. And many of them are coming with very different religious backgrounds and traditions than Americans prior to 1965. So what will, in the end, protect religious liberty and diversity in America is the religious diversity in America, thanks to the religious diversity of Americans.